Sure. Okay. Thank you.
So this leads to a second question as well, which is whether Twitter should only be challenging the orders or should be challenging the law itself. Now, it could challenge the law itself, but I'm not sure how exactly that would be helpful in this case, where there's a much easier ask of the government not complying with the law that they've laid down, which is what Twitter's case is. So they could challenge the law itself. I do believe that there are grounds, for instance, in 2014, in the Shreya Singhal case, the Supreme Court didn't actually look at Rule 3 of the intermediary guidelines rules, and they didn't actually look at Section 69A in very much detail either. And one of the requirements for Section 69A, which is one of the provisions in Section 69A, which is the confidentiality provision, Rule 16, that in a way was indicated by the government, by the court, as being ultra vires. Because the court, if you read the judgment, assumes that one of the built-in safeguards for this is the publicity of the order, whereas Rule 16 actually prohibits publicity of the order by intermediaries. That it's a confidentiality requirement. So the court says that Section 69A is fine, in part because the orders are public, whereas Section 69A rules actually don't make the order public. So that's something that actually needs greater clarity from the Supreme Court itself or from high courts. And so clearly there are other kinds of grounds as well to challenge the rules and Section 69A, as well as the intermediary guidelines rules under Section 79, Rule 3 and others included. But I don't think it's a bad thing that that Twitter is challenging only the legality of the orders that they received. That's at least a good first step.
Right.
I know of only 3 instances in which companies in India have gone to court or have pushed back against, legally that is, through legal processes, against governmental orders, those being one of Yahoo India, which challenged the ability, the legality of the CCA, the controller of certifying authorities, to request user data. And they were fined for that, and then they went to court to challenge that fine when they refused to comply with these orders, saying that the order itself was unlawful. Then there's the case of WhatsApp, which has challenged the requirement under the intermediary guidelines of essentially breaking end-to-end encryption, communication transparency requirement. And that's been challenged by Meta, by WhatsApp. And then there's this current case. Other than these, I actually don't know of other situations where companies have actually gone to court to safeguard user rights as opposed to just getting themselves out of soupy situations, such as saying, we're not responsible for defamation, the user is responsible for defamation, and things like that, where courts, where companies have very often gone to court. They're in court all the time in different parts of India. But that's usually to escape liability themselves. But this kind of a situation where they actually stand up for user rights is highly unusual. I actually don't know. I only know, as I said, of these 3 instances. And so I'm glad that Twitter is actually taking this action. So those are the 2 broad sets of comments that I had. One, to your question of whether Twitter could have done something beyond this to challenge the law itself, and 2, and which is what I just now answered after the recording began. But then earlier, speaking about how uh, the own the ways that Twitter could actually challenge this, the that there are problems in between what the law lays down under Section 69A and the rules they're under, and what the Supreme Court said in the Shreya Singhal case. There's a disjunct and between what's laid down in Section 79, Rule 3, and the analysis again in the Shreya Singhal case, where they don't analyze that at all, and so on. So there are many problems in the current state of the law, and sure, Twitter could have done that, but I'm glad that they were at least doing this.
Right. Thank you. And sort of just to ask you, you mentioned that companies in India are in court all the time, but that's to protect them from their own liabilities that they may be facing. And it's very rarely to actually protect, the rights afforded by Indian laws to users of the internet. I just wanted to ask, just in your opinion, why do you think that is the case? Why do companies refrain from doing that, whether they're Indian or from abroad?
So there could be two possible reasons. So one is they actually, there could be many possible reasons. I can't read what's in their mind.
Yeah.
But one legalistic reason potentially is that many companies have earlier, their main argument in court has been that the Indian entity is not responsible for content. Okay, so Google India, they say, is only responsible for marketing in India. Okay, they're not a direct intermediary either. Okay, essentially Google USA, okay, the Mountain View based company, is what is acting as an intermediary for these for speech of Indian users as well. So if that is your legal stand, then you're in less of a position to actually, as an Indian entity, fight for the rights of Indian users.
Right.
It's only as a US-based entity that you can possibly fight for this, which again is has its limitations. Now, Yahoo India was actually an Indian-based company that was not responsible for just marketing. They were actually responsible for content, because Yahoo, long time ago, since at least in 97, 98, I think it was, they ran into issues with regard to a case filed to prohibit Nazi memorabilia being sold on through Yahoo services and being found through Yahoo services and so on. Whereas Yahoo at that time claimed that, and this was in France, claimed that, we are an American company, we're not subject to French jurisdiction, okay, on this matter. Okay, so you can't prohibit us from doing this. And when and soon after that, Yahoo's strategy was to have separate entities in different countries to limit their liability in each country. So it's saying that, okay, you can order Yahoo France to ban this kind of content, but you can't order Yahoo USA or Yahoo India or any other entity to block this kind of content as a French court. So Yahoo used that strategy, whereas other companies like Google used an opposing strategy, saying everything is US based. We're the US entity is the one that's providing services. So you as India don't actually have jurisdiction over us.
Right.
So and that's they took that tack, and so perhaps that accounts for some of the differences, but I'm not convinced that that's the main reason. That's one potential reason, though. The main reason perhaps is that they just didn't want to antagonize the Indian government.
Right.
Perhaps it's just that. I
And
don't know what the reason is, frankly, though.
yeah, I mean, it's a bit of a mind reader question, so I don't blame you for that. But I think one question that we've also seen coming up is that why don't Indian companies actually go and challenge these kinds of rules in court? Why is this sort of seen more by foreign companies? And do Indian companies get treated differently when they bring these kinds of challenges to court compared to a foreign entity?
So we don't know whether they get treated differently because I don't know of any instances where Indian companies have done this.
Right.
Uh, Now, Indian companies and foreign companies, given the legal requirements of having a, a compliance officer in India and so on, okay, who can be held liable, perhaps the distinction isn't as important anymore as it once was.
Right.
Okay, now an employee of a foreign company as well in India can directly be held responsible, right, for non-compliance with Section 79A and so on. And Section 69, Section 79 and Section 69A as well. So given that, perhaps legally there's not as much of a distinction now, since the foreign companies also have greater skin in the game, as it were. Why don't Indian companies do this? I have no idea. They should be asked. Perhaps they feel they have never been asked to remove content that was lawful. Perhaps they feel they have never been asked to reveal user data that wasn't a lawful request. Perhaps they believe that the government has done no wrong whatsoever. And some companies actually try to make their brand on that. And I'm not going to take names, but some Indian company, or Indian social media company that I know actually prides themselves on cooperating more with the government for removal of content and for providing greater access to data to law enforcement, etc. Um, and has publicly stated this as the reason they're better than foreign companies at conferences, etc. I've heard that. So perhaps they see that as something that sets them apart. So not standing up for user rights, okay, is something that is good for their business, perhaps, because it pleases the government more. For some companies, that might be a consideration, but I don't really know why they don't do as much to stand up for user rights.
Right. Fair enough. Thank you. And I think my next question is sort of leading on from that, where we've seen the Minister of State and the Union Minister for Electronics and Information Technology repeatedly saying that, if you're a foreign company and you want to do business in India, that's fine, but you have to comply with Indian laws. Indian laws are not going to be dictated by what someone in the Bay Area is saying, essentially, seems to be the bottom line.
That's absolutely correct. Indian law should not be dictated by what someone in the Bay Area says, but Indian law should be dictated by what the Indian Constitution says.
Right.
And the Supreme Court in the past has found, in case of laws passed by the Indian government relating to internet censorship, that Indian laws do not comply with the Indian Constitution. So when these foreign companies are actually sometimes complaining about it, when Indian NGOs are complaining about it, when policy experts are complaining about it, when lawyers are complaining about it, it's not because these Indian laws fail to comply with the First Amendment or fail to comply with the desires of people sitting in Silicon Valley, but because they fail to comply with Indian law and the Indian Constitution.
Right. And I think that kind of brings me to my next question, which is essentially, of course, Section 69A was upheld a few years ago, but in your opinion, what amendments do we need to see made to the provision, given what we've seen over the last year in terms of the rise of blocking orders? how can we bring accountability into how it's used? And I think the first question, just to set the foundation for that, is to cover the base, which is essentially, do you think that the Indian government is following the approach mentioned by the Supreme Court in Shreya Singhal regarding due process when it comes to Section 69A orders?
No. So firstly, the Shreya Singhal judgment, as I mentioned earlier,
Yeah.
assumes that orders are public and
Right.
can be challenged effectively, and that legal space exists. And the truth is, these orders are not public. They can't be challenged effectively. And so the Shreya Singhal judgment either misconstrued the law, that's one way of looking at it, or the law has not been amended, keeping in mind Shreya Singhal, okay, which would be another way of looking at it. Rule 16, which is the rule imposing confidentiality, continues to exist and
Right.
continues to be followed. So, and that, in my opinion, is clearly unconstitutional because it doesn't allow for natural justice. It doesn't allow for audi alteram partem, a hearing of the other side adequately, because in some cases the people whose content are being affected are not being given a hearing. In actually most cases, I would argue, they're not being given a hearing. We know of MPs in India, okay, members of parliament's accounts are still blocked in India without the government having provided any justification whatsoever for why they were blocked.
Right.
Okay, how in a constitutional democracy can we allow for this situation, right? And it's just stunning to me that even today, it's Twitter accounts of MPs are still carry a sign saying blocked in India due to legal requests by the government, without the government having provided any justification, any hearing to the MP, without it having provided any or even having publicized the order under which this was done or why this was done. We still do not have an official explanation. Now, we cannot live in a state where the government has the power to ban something, but does not need to provide any justification for such a ban, okay, which is assumed in the Shreya Singhal judgment, that such a justification is being provided. Now, it isn't being provided, and in my opinion, without speaking orders, without orders that make it clear why something is banned, under what law it is being banned, okay, what provision of the law that speech actually violates, and so on and so forth. These orders are not legal. Secondly, you asked me about changes required to Section 69A, apart from that on confidentiality and transparency, where I'd argue that you need to publish all orders of content that is blocked, and say why it is blocked, what provision of the law it violates, and so on and so forth, as well as the deliberations that went into such a block, the minutes of the meeting, and what evidence was provided, etc. All of that should be made public. Apart from that, there's also the question of time limits, right? How long are things blocked for? Should blocks be permanent blocks? Because there is no provision for temporary or permanent blocks, and so on, in Section 69A and in the rules. So that's something that needs to be brought into the rules. Okay, there needs to be periodic evaluation of things that are blocked, because we, under the standard laid down in Shreya Singhal, which is of imminence, plays a role, right? Now, if something very easily could be an imminent threat to public order at one point, without being such an imminent threat at a later point in time, okay, and in a powder keg situation, something could legally be blocked, which once that powder keg situation has disappeared, might not be as threatening anymore. So there is unfortunately no reevaluation provision in the rule, so that needs to be brought in. Apart from that, there are no clear guidelines as to necessity and proportionality, as to when something may legitimately be blocked under these rules. Okay, rather it just gives people the power to block for these for a set of reasons, but doesn't actually set any kind of thresholds, doesn't actually set requirements of proportionality and so on. So because necessity and proportionality don't play any role in it, okay, these I would say that the rules are suspect and that they actually need to be amended as well. So on a wide, for a number of new changes need to be brought into the rules, in my opinion, to make them comply with international best standards in terms of the ICCPR, the International Covenant on Civil and Political Rights, and so forth, and as well as the Indian Constitution and how it's been interpreted by the Supreme Court in free speech cases.
Right. And I think you kind of naturally went through the answers of all my questions there, which actually brings me to the last one, which is essentially, and I think this is a question on all of our minds because we're all inherently outward looking when we think about free speech, is how does India's stance on these blocking orders match up against the global precedent on blocking of certain content online? Which direction is India headed in? Are we headed towards a more kind of reflective approach, rigorous approach, ring-fenced approach, or are we heading the other way as seen in certain authoritarian states?
So I don't like this easy dichotomy into authoritarian states and democratic states and so on. Many of the laws passed in Germany when it comes to the internet can easily, in my opinion, be called authoritarian, and so on and so forth. So Indian laws on these issues are terrible. I think I laid out a number of reasons why they're terrible. And while speaking only of 69A, on 79 itself, there's a whole lot more to be said. But let me also point out that India is not an outlier. It might have been an outlier in 2011 and so on, but increasingly more and more countries are following in India's footsteps and are seeking to bring in worse laws that, in my opinion, do not uphold freedom of expression, do not strike a good balance between, say, things like hate speech, things like misinformation, which is now like this massive, which is now seen quite wrongly, in my opinion, as a massive threat, and so on, and doesn't and the laws that are being brought in various countries to combat terrorism and various other things do not strike, in my opinion, a right balance. And so India is not doing well, but is increasingly has more and more company in not doing well on this front.
Right. And you mentioned sort of briefly while speaking that you think misinformation is kind of wrongly painted as a bigger threat than it might be. Could you
Yes.
elaborate on that a little bit? I'm just interested to know.
Sure. A lot of okay, a simple example. Let's take Twitter. Now, Twitter, we know, has done a lot on misinformation in the recent past, banning accounts. Even, for instance, it suspended my account for a while because of a tweet I put out on COVID, okay, where I published something that was wrong, noting that it was wrong, okay, but that itself got my account suspended, and I couldn't access my account unless I chose to delete that tweet. And in the end, after 3 weeks, I finally chose to delete it. Now, that same Twitter, it in its in its content discovery page, right, put out summaries which said things like that scientists had found that vaccine-induced immunity was longer lasting and better than natural immunity. Okay, now the story that it provided, that it linked to, actually made no such claims, but that was Twitter's summary of it. And that summary was a classic case of misinformation. Okay,
Right.
that is, no studies had actually held that. Even the article that Twitter itself linked to, okay, did not make that claim, but Twitter made that claim. Now, who's to hold them accountable, right? And are they should Twitter ban Twitter? Should they be prevented from putting out these Twitter stories for a period of 2 weeks until they delete it or something? It's, the idea that it's easy to say what is misinformation, and if you look at lots of fact checks nowadays, okay, it's not about actual. Okay, let me phrase it differently. If you look at a lot of fact checks these days, many of them are actually just about the context, and the ratings that are provided by fact checkers as to whether something is true or false, and the graded rating actually, to me, makes no sense, because very often they're taking things that are arguably true or arguably false and just painting it as, pants on fire false, and four Pinocchios and this and that, and it's ridiculous. Lots of things that, in my opinion, are clearly, things that were born out of misinformation, such things that people believe, for instance, about Russian hacking and Russian hacking of U.S. elections and Russian campaigns in that led to Brexit and so on, are classic instances of misinformation. Okay, but they're repeated by people in mainstream organizations and mainstream news channels, okay, by mainstream newspapers, okay, and that is not treated as misinformation, on the other hand, okay, as it should be. There is no proof for most of the claims that are being made, okay, and these claims have been made for multiple years, okay, and the lies just keep piling on, right? So there are many instances of this kind that I can think of, which are or are not misinformation based on one's political views rather than based on evidence. Okay, so it's misinformation when someone with a different political view than mine makes something that resembles falseness, some resembles falsity, but it's not misinformation when I say something that could possibly be true, or people allied with me could say something that could possibly be true, but isn't actually necessarily true. It has what Stephen Colbert once called truthiness, right? So whether something has falsiness or truthiness, okay, completely depends on one's political affiliations, in my opinion, okay, and what team one wishes to prop up at that moment, and doesn't have as much to do with the underlying claim itself. In far too many cases, I'm not saying this is universal, but in far too many cases, that is how the actual politics of it plays out, and that's quite unfortunate. And so, but based on the stupendously wrong claims made around Cambridge Analytica, made around the 2016 U.S. elections, the around Brexit, and around again the 2020 U.S. elections, and so on. People somehow think that misinformation is the biggest problem facing us, whereas it is nowhere near the biggest problem facing us. The kinds of things that they say are problems right now were problems in 100 years ago. Okay, false political claims have existed as long as politics has existed. Okay, you have detailed debates which are still just as lucid and as illuminating, the Dewey-Lippmann debates from 1920s, okay, around things like misinformation, around issues of gullibility of the public, around the question of the role of media and the role of news, around yellow journalism, around all these things. It's just as relevant today. It's not something that has been created due to social media. It's not something that's been created due to Russian hacking and Russian bots and whatnot. Okay, yeah, and the some evidence on how much influence uh, other countries by buying advertisement and by deploying bots have had. There's truly very little. The evidence that exists actually points in the opposite direction, that there was not much influence. Okay, and so to ignore all that and to keep uh, churning out these narratives about how misinformation can swing elections and so on. And, again, the most detailed report into Cambridge Analytica, which was conducted by the ICO in the UK, actually did not find any evidence, and they were people who were really strongly looking for evidence to say data protection is important, and these people breached data protection norms, and they were looking for evidence, and they did not find any. Right, so it's ridiculous, and for me, there are far worse things. And one of the worst things that we've seen in recent times is are things such as Twitter and Facebook, etc., being overzealous in stamping out misinformation, saying that things like, again, to take the U.S. context for a second, that the Hunter Biden laptop story that New York Post put out in October 2020, okay, that had been blocked on saying that it was part of a Russian disinformation campaign. And it's clear that that story, okay, it has subsequently been backed up by New York Times, by Washington Post, yet that was actually blocked by Twitter for weeks, by Facebook. People couldn't share links to that, not even in direct messages, forget about tweeting it publicly, couldn't share links to that story to a news article. They couldn't share links to a news article because of all these fears around Russian disinformation campaigns.
Right.
And that's ridiculous, in my opinion.
Right.
And it has concrete harms.
So I have one more question, which I should have asked you earlier, but I think in the course of the conversation, I got derailed a bit, but thank you very much for this. That was very helpful. Which was essentially that you mentioned rightly that this isn't the first time that Twitter has gone to the union and said that these tweets may not fall within the purview of Section 69A. And the union has already gone back on its orders in some cases mentioned in the petition. But the question I think Nikhil and I had was essentially, is this a question of timing? Because if this has happened already, why make a court case about it this year? Why not do it last year, as you rightly said? Why does timing factor into challenges like this? Does it add a dimension to the case? Is there in sort of anything more that can be read into how these pitches are?
I have no idea about that.
Okay, fair
I
enough.
don't really have any. I don't know how the timing has changed between last year and this. What political factors have changed? I can't think of anything significant. And so, yeah, I don't really have anything to offer in terms of analysis on that. Sorry.
No worries. Maybe it's good I saved it for last then. All right. I think that brings me to the end of my question set. Is there anything else that you wanted to add that you felt like you may
No,
want to add?
no, thanks. And it's been an interesting chat.
Thank
Cool.
you.
Catch you later.